2,000 on the terroristic threats, and then 500 on the other charges, which should total out to $3,500. And there will be a special condition, sir, that you not return to that location.
I believe it's Pierce, and no drugs, alcohol, or weapons while out on bond. Good luck, Ms. Wheelwright.
Thank you.
Thank you, Judge.
You're welcome.
Next is position 25 and 26, Ms. Rosen.
Yes, good afternoon, Ms. Rosen. You've been charged in case 24 CR 006204J with theft by deception, and in case 24 CR 006205J with theft, 2 counts of theft by deception. Is there a history, Ms. Harvey?
3 cycles, Your Honor. Last arrest was December 22nd, 2016 for a DUI out of Fulton County. That was reduced to a non-fingerprintable offense. There does appear to be a hold out of DeKalb County for larceny. There is an additional open case out of Fulton County for felony theft by deception. Case number 24 PI 006396. It appears this case was on the felony calendar today, Judge. Nothing further.
Thank you.
It's my case, Your Honor, or 2 cases, I should say. Position number 25, the date of that incident is May the 30th. Both of these cases deal essentially with the same facts on different dates, Your Honor. Loss prevention conducted an investigation at the locations of TJ Maxx here in the metro area, 2 of them specifically, one on Buckhead Loop and the other at Medlock Bridge Road. They both carry high-end items. Investigation revealed that the defendant purchased a $1,600 purse at the Buckhead Loop location on May the 21st. And then on May the 30th, went into the Medlock Bridge location and used the documents from her purchase of that purse to return a different purse and get the full value of that purse refunded to her. So now she has the purse, that's $1,600, and her $1,600 back that she paid for the purse with, and gave TJ Maxx a janky purse. She was seen on surveillance, photographs of her items and documentation through her transactions, as well as her car, her Tesla that she left the location in, were all used to identify her.
It's as good as it's going to get, people.
$1,600 purse.
Janky purse.
The first case, Your Honor. The second case has 2 counts. On the 21st of May, same day, at the Buckhead Loop store, she purchased a black pair of shoes for $599. On the 20th of May, she went to the Medlock Bridge TJ Maxx location and returned a different pair of shoes, not the nice $599 shoes, and then got her $599 back. So now again, she's got shoes and her money back. The second count in that case, Your Honor, is from a purchase on June the 27th, July the 2nd, and July the 9th, all for multiple items of clothing totaling a value of $569.93 that she then returned on July the 11th at the same Medlock Bridge Road location, where she returned items that were not the items she originally bought, weren't the same color, weren't the same items, but were like a blouse or a pair of pants or a pair of sweatpants. They just were conveniently not the ones that she'd purchased that are high end.
It's the only bright spot in the 2-hour stream.
$569.93 back in a refund. We did request a transfer of this case, Your Honor, based on the value, and that was declined this morning. So you've got 2 cases in front of you, all for the same behavior, and the total value taken just in these 3 transactions over $2,300. There is history, Your Honor, but it's minimal. I do think it is of note she's got an active larceny charge, and it looks like maybe there's a first appearance felony situation as well. The state would be asking for a $2,000 surety bond on both of the cases. Stay away from all TJ Maxx locations for goodness sakes. No drugs, alcohol, or weapons, and we'd request a BHET or an MHET. Thank you.
We know what bond she got at felony first appearance this morning? Ms. Harvey?
I'm checking, Judge. Let me see.
Okay.
Thank you, Ms.
Judge, it
Allen.
appears just
Competent
while
and
we're
fun.
looking, the felony charge, the 24 PI is for the same incident, though, from May 30th, which is case number 25. So I don't know when Ms. Allen mentioned that the DA's office declined, whether that was the case. It looks like it is. So, but I guess we'll hear confirmation whether she went to Superior Court or not in a second. I would ask the court to consider a UJR, Judge. My client is 65 years of age. She runs her own business with her husband. This is not a situation where she was arrested, bonded out, got rearrested. These warrants came essentially back to back to back. She has a DeKalb County hold. From speaking to my client, there's no indication of any type of MH or BH, Judge. I would ask for a UJR. I've explained to her that she'll be going straight to DeKalb to deal with that. I'm guessing it's similar type charges, but I don't know, Judge.
Okay. Any information for me, Ms. Harvey?
No, Judge, I'm not showing the bond amounts.
Okay, thank you.
I'm sorry. She got $100 bond.
Okay,
Well, that answers my question.
thank you. All right, so for position 25, it's going to be a $2,000 signature bond through pretrial level 1. Stay away from all TJ Maxx stores and no drugs, alcohol, weapons while out on bond. For position 26, it's going to be $1,000 on each charge, signature bond through pretrial. Makes for a total of a $2,000 signature bond through pretrial level 1. Stay away from all TJ Maxx stores and no drugs, alcohol, weapons while out on bond.
Thank
Good
you,
luck
Judge.
to-
Thank you.
Next is my last one, Your Honor. Position
Okay.
14, Kenneth Jones.
Good afternoon, Mr. Jones. You've been charged in case 24 CR 006196G with theft by taking. Is there a history, Ms. Harvey?
Yes, Your Honor, 55 cycles. Last arrest, October 20th, 2020, out of Fulton County for a probation violation.
Trial.
For theft, appears to be on probation out of Fulton County for theft by shoplifting. Sentence March 15th, 2019 to 9 years probation. There is an additional open case out of Fulton County for simple battery and theft by shoplifting. Case number 24 PI 004036. In addition, Your Honor, there are convictions from 2020 for theft by shoplifting, 2018 battery, 2017 theft by shoplifting, 2016 identity theft fraud, 2013 criminal trespass, 2012 theft by shoplifting, 2010 aggravated assault, 2008 criminal damage to property, 2007 robbery, terroristic threats, possession of a controlled substance, 2005 disorderly conduct and theft by shoplifting, 2004 theft by taking, 2002 theft by shoplifting and criminal trespass, at least 1 FTA and 2 probation violations in history. Recommendation for pretrial, Your Honor, is level 3 and nothing further.
Your Honor, his last arrest was actually May 22nd of this year for shoplifting, and he is a recidivist, so that was transferred to the DA. He's been in custody since May 22nd. This incident took place in March. However, the warrants were signed on August 28th, and he was booked on this case on August 31st because they did not immediately identify the defendant as the suspect in this case, and that's the basis for the delay. But this incident happened on March 15th at the Kindred Healing Center at 1800 Jonesboro Road. The defendant is on surveillance camera stealing an air fryer valued at approximately $50 from the location. Initially, the Kindred Healing Center, they did not recognize the defendant and took some time to identify him. However, he was identified from other officers in the area, most recently from the officer that arrested him for shoplifting back in May. And he's got 56 arrest cycles, so the officers know who he is. And then his ID was further confirmed by comparing photos of the surveillance to photos of Mr. Jones. The state is requesting a $1,000 surety bond, a stay away from the incident location, no weapons, drugs, or alcohol while out on bond. Thank you.
Trejo?
Yes, Judge, we'll ask the court to consider a UJR bond on this case just because my client has been in custody for 103 days, Judge, and because there are other things that are holding him. That probation violation is still pending, and he does have that theft by shoplifting that was referred to the DA's office. Judge, my client is homeless. He indicated that he's been homeless for some time. He has had a social worker visit while he's been in custody. And furthermore, Judge, as I mentioned previously, he has other things that are holding him. He wouldn't be able to make a bond if he was given one to begin with. Therefore, we are asking for a UJR bond so that once he resolves some of these other issues, this doesn't end up being something that holds him longer than needs to be held.
Okay, it'll be a $5,000 signature bond through pretrial level 3. Stay away from the 1800 Jonesboro Road address. No drugs, alcohol, weapons while out on bond. Good luck, Mr. Jones.
Thank you, Your Honor. May we be excused, please?
Yes, have a good rest of your afternoon,
Thank
Officer
you.
Milton.
Bye-bye.
See you next time. Okay, who do we have next?
Next, Your Honor, we have position number 1, Mr. Alexander.
Good afternoon, Mr. Alexander. You've been charged in case 24CR006181G with battery. Is there a history, Ms. Harvey?
Yes, Your Honor. 23 cycles out of Ohio and 2 cycles out of Kentucky. The last arrest was out of Kentucky, August 12th, 2015, for possession with intent to distribute heroin. That was a conviction, Your Honor. In addition, there are convictions from 2013 for attempt escape, 2013 possession of a controlled substance, 2009 assault, 2008 felonious assault, 2005 possession of a controlled substance and possession of criminal tools, and a 2002 conviction for trafficking drugs. Recommendation from pretrial is a level 2. Nothing further.
Your Honor, this incident took place August 31st, 2024. Officers responded to 4725 Walton Crossing Southwest regarding a fight in progress. The victim in this case is Jessica Freeman. She stated that she was in the car with the defendant, who was her boyfriend. She turned on the air conditioning and the defendant got upset about that, apparently. And also there's an issue with the car where the seatbelt signal keeps going off, and that was irritating as well. She stated that the defendant snapped and started calling her names and then punched her 4 or 5 times. And the warrant also states that he quickly choked her. The officer noted that the victim had swelling to her left eye and lip. We've not been in touch with Ms. Freeman today. The state's requesting a $2,500 surety bond, no contact with Ms. Freeman, a stay away from the incident location,
Just a quick
anger
note.
management courses, no weapons, drugs, or alcohol while out on bond, and if the court can sound for Ms. Freeman. Thank you.
Jessica Freeman's on the line and wishes to address the court. Now is your opportunity to do so. Mr. Trejo?
Yes, Judge, we would object to a stay away order as this is my client's home where he is on the lease and where he pays the rent. He indicated to me that he has no issues with no further contact with the other party. My client has been in Atlanta for 2 years, though he does have substantial history from out of state. As the state mentioned, he has no history dating back to 2015. He's gainfully employed. He came down to Atlanta so he can work and put some of those prior issues behind him. That has largely been the case up until now. And for that reason, Judge, we would ask for a $1,000 surety bond, and we would object to the stay away order.
He's really slowed down on the heroin dealing and the assaults.
Okay, so you're telling me
least
that Ms.
getting caught.
Freeman does not live at the Walton Crossing address, Mr. Trejo?
Judge, I believe she may have her own address. I know that that is his address and that he was living there and that he has
Your Honor,
concerns about a stay away order.
I'm showing that according to the citation he received, he put his address as 706 The Trace in Lithonia. So it was my understanding that the incident location was her residence.
Can we clarify that, Mr. Trejo? Does he need to go back to the Walton Crossing address?
I'd like to clarify that with him, Judge. I know he mentioned that he has, I think, family at the Trace address and that he had been staying there. If I could clarify that with my client and then
Go ahead.
make that representation to the court.
Go ahead. Can we just do that here? Can
Sure
you just
thing.
ask-
Mr. Alexander, can you please just confirm which address is your actual address, whether it's the Trace or whether it's the Walton Crossing address?
My address is the Walton Crossing, New Jersey. That's the one with my name on the lease.
Does Ms. Freeman live there also?
Yeah,
Okay, well, if Ms. Freeman lives there, he's not gonna be able to go back there, even though his name, if she's residing there. So it'll be $1,000 good bond, no further contact with Ms. Freeman. Stay away from the Walton Crossing address. You can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. If Ms. Freeman happens to leave that address, of course, he can go back and reside there if she is not residing there, but because he's to have no further contact with her, if she is residing there, he has to get his belongings and find somewhere else to reside. All right, good luck to you, sir.
next is gonna be position number 2, Mr. Nathan Burgess.
Good afternoon, Mr. Burks. You've been charged in case 24 CR 006182B with criminal trespass. Is there a history?
Yes, Your Honor. Last arrest August 20th, 2024 out of DeKalb County for criminal trespass. That was a conviction, Your Honor. In addition, there are convictions from 2024 for theft by shoplifting. 2 additional convictions from 2024 for criminal trespass. A 2023 conviction for criminal trespass, as well as a 2020, 2018, 2017, and 2016, all convictions for criminal trespass. There's a 2023 conviction for disorderly conduct. At least 2 probation violations and 1 FTA in the history. Recommendation from pretrial is a level 3, Your Honor, and nothing further.
Judge, this incident took place August 31st at the H.E. Holmes MARTA station at 70 Hamilton E. Holmes Drive. An officer was patrolling the area and saw the defendant loitering. He asked him to either get on a train or a bus or station. The defendant then left and then he returned again. And at that point, he was issued a criminal trespass warning and was asked to leave again. He left again and then came back again. And then he was placed under arrest. And once he was placed under arrest, it was also determined that the defendant has 3 active suspensions with MARTA, stemming from, let's see, July 2024 and extending until November 2024. It looks like he's been issued suspensions at multiple stations and they're possibly not matching up, but all the timeframes are fairly similar. The state's requesting a $500 surety bond to stay away from MARTA, no weapons, drugs, or alcohol.
Trejo?
Yes, Judge, we are asking for a signature bond in this case due to my client's indigence. He indicated to me that he does not work, he does not receive any government benefits. He lives with his mother, who is the one who's responsible for paying rent and paying the other bills. He went to school through the 11th grade. His entire family is here in Atlanta. He is local to Atlanta, has lived here his entire life. Our main concern, Judge, is his ability to pay any bond in order to be released.
Okay, it'll be a $1,000 signature bond through pretrial level 1. Stay away from MARTA and no drugs, alcohol, weapons while out on bond. Mr. Burks, I'm gonna let you out, but if you go back to MARTA, they're gonna rearrest you again. And the next time, I'm not gonna let you out in a signature bond, so don't go back to MARTA, okay?
How long suspension is?
Your Honor, did you mean level 1 or level 3?
I meant level 1 because of his, I want to make sure that he complies. So, okay, Mr. Burks, good luck to you, sir.
Next, Your Honor, is going to be position number 7, Mr. David Craig. Your Honor, I see they put another charge on him. Do you want me to put this to the back of the calendar?
Yeah, let's, I'm not sure who's representing him, but given his charges, and I know that we have 3, I believe, that have the same charge, let's put them all at the end of the calendar, okay?
All right,
Thank you.
you go to the back. Next, we're going to go to position number 12, Mr. Michael Grubbs.
Good afternoon, Mr. Grubbs. You've been charged in case 24 CR 006189C with battery family violence. Is there a history, Ms. Harvey?
4 cycles, Your Honor. The last arrest was out of Cobb County for a failure to appear, January 22nd, 2020. It appears he received first offender in 2015 for unlawful to possess, display, or use any false identification document and furnishing or possessing by persons below legal age of alcohol. Recommendation from pretrial, Your Honor, is a level 1 and nothing further.
Your Honor, this incident took place August 31st, 2024. Officers were dispatched to 22 Gertrude Place regarding a domestic dispute. Upon arrival, they made contact with the defendant, who stated that he mushed his wife's face and then got dressed and went and sat on the porch. The officer then spoke with the victim, Farah Saranetti. She stated that the defendant was asleep on the couch and was watching football. When he fell asleep, she changed the channel to Netflix. The defendant woke up upset that she had changed the channel. So she changed it back to the football and then got his computer to watch a movie. And when she was trying to watch a movie, the defendant came in and told her, "You're not using my laptop," snatched it away, and then slapped her in the face twice, causing her to have a bloody nose. We've not been in touch with Ms. Saranetti today. I believe she may be on the Zoom. The state's requesting a $2,500 good bond, no further contact with Ms. Saranetti, stay away from the incident location, taking complete and anger management course, and no weapons, drugs, or alcohol while out on bond. If the court can sound for Ms. Saranetti.
Ms. Saranetti, is this you under Farah's iPhone here?
Yes.
Okay,
I mean,
if you'd
she
like
was
to
using
address
his
the court, I
laptop.
need for you to raise your right hand. Do you swear from the testimony you're about to give before this
My
court will be the
God.
truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down, ma'am. What would you like to tell the court?
I just would like to add that this is the first time I have ever experienced this with him, and he is battling 3 different infections, a kidney infection and some other organ infections. He had a high fever at the time. I do feel like it is, and he's on several medications. Just feel like it might be related, and that's all I have to say.
If you like him back in the household,
That's fine.
you're not afraid of him?
No,
And you said that this has never happened before?
never.
Okay, that a response as such as "that's fine" causes me concern. Is it fine, or or are you just saying it was fine? Do you want him back? Or would you rather him, for the meantime, find someplace else to stay? You can tell me the truth. I expect you to.
It is the first time, and my gut just tells me it's related medical, and the fact that he was asleep, I feel fine. I do.
Okay, so you're not afraid of him, is what you're telling me.
No.
All right. Thank you for being here this afternoon, Ms. Saranetti. Yes, Mr. Trejo. Ms. Desiano?
I'll reserve my argument for the end, Your Honor.
Trejo?
Yes, Judge, given my client's wife's representations, we would ask for $1,000 surety bond on this case. My client indicated to me that he is a operations manager with a event and wedding planning company, so he is gainfully employed. He indicated to me that he and his wife are renting a property right now while they're having work done on their house. That she is not working at the time, that he does have significant financial concerns based on the situation. He's been taking on additional part-time jobs, at least 2 of them at this time. He does have a bachelor's degree from Georgia State and has been in Atlanta for 24 years and does have family here. So we don't have any concerns about his not appearing to court when called upon.
Okay, Ms. Desiano?
Your Honor, I think the court can see the hesitancy in the victim here, and that certainly concerns the state, because if this is a medical issue, and it seems to me that this may be out of character, however, it may be something that's medically induced, and it's not something that appears to be going away. This just happened a couple of days ago, and I certainly understand that the victim would like the defendant to come back home, and it's possibly awkward with him sitting right there and her being able to be honest about how she truly feels. And given that this just happened, these bond modification conditions can be modified at a later point. And I think what's best for the victim at this point is to have no contact and let these parties cool off, and then we can readdress contact at a later point when these folks have had some time to cool off.
Okay, it's going to be a
Reasonable argument.
$5,000 signature bond through pretrial level 1, 5 days of anger awareness, no further violent contact with Ms. Serenetti, and no drugs, alcohol, or weapons while out on bond. Good luck to you both. Who do we have next?
Yeah, that's the thing. I think he pays the bills.
Next is gonna be position number 13, Mr. Yao. Gao.
Yes, good afternoon, sir. You've been charged in case 24 CR 006190C with simple battery and willful obstruction of a law enforcement officer. Is there a history, Ms. Harvey?
One arrest out of New York from July 6, 2022 for obstruction of breathing or blood circulation. No disposition was listed for that case, Your Honor. Recommendation from pretrial is a UJRJA. Nothing further.
Your Honor, this
Yes.
incident happened September 1st, 2024. Officers were dispatched to 1163 West Peachtree Street regarding a dispute. The victim in this case, first name Weiyi, last name Han, stated that her boyfriend grabbed her and slapped her on the left side of her face and then snatched her cell phone. The victim advised the defendant asked her to move in with him, and she agreed and started to move her belongings, and then during the move changed her mind and told him that she did not want to live with him, and that's when she was struck. The victim also noted that the defendant has been violent with her in the past, but she's never made a report until now. The officers spoke to the defendant, and he made a statement to the police where he told them that the victim told him to slap her, and so he touched her face. The officers then went to place the defendant under arrest, and he resisted arrest on the basis for the obstruction. The officers searched the defendant incident to arrest and did find the victim's cell phone, even though he told police he didn't know where it was. We have been in touch with Ms. Han today. She states that she and the defendant have been together for about 3 months. They do not live together. The incident location is her apartment. She stated that the defendant's been aggressive with her before this incident. This is the first time she's called the police. She is afraid of him. She confirmed the events in the warrant. She states that she has expensive belongings in his apartment and would like to know how she can retrieve those items. She stated that she has the defendant's car and his house keys. She would like a no contact and a stay away and a one-time escort for both parties so that they can each get their belongings from one
She's
another's
done.
apartment.
Good for her.
The state's requesting a $1,000 good bond on each count, no further contact with Ms. Han, a stay away from her residence, taking complete anger management class, no weapons, drugs, or alcohol. And I believe Ms. Han's on the line, Your Honor. Thank you.
Ms. Han would like to address the court. Now is your opportunity to do so. Of course, you do not have to, but if you would like to, you have to unmute yourself, activate your camera, and I'll have to swear you in.
Yes, Your Honor, I'm here.
Okay, did you hear would you like to address the court?
Yes.
Okay, then you'll have to activate your camera for me. You hear me, Ms. Han? Are you with me, Ms. Han? while we wait for her, Mr. Trejo?
Yes, Judge, given my client's lack of history, we would ask for a UJR on this case. Judge, my client, as the state mentioned, this is not my client's address. We have no issues with the stay away order, provided that my client may have a one-time law enforcement escort for each party to retrieve their items from the other's custody.
Your Honor, to be clear, he does have history. He has a 2022 criminal obstruction of breathing or blood and second-degree harassment out of New York.
All right. Doesn't seem like Ms. Hahn is with us anymore. As such, for the simple battery, it would be a $2,000 signature bond through pretrial level 1, obstruction, $1,000 signature bond through pretrial level 1, makes for a total of a $3,000 signature bond through pretrial level 1. No further contact with Ms. Hahn. Stay away from the West Peachtree Street address.
I really want to see Ms.
They
Hahn.
can
I'm
have
not
a
gonna lie.
one-time police escort to retrieve any belongings and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir. You're on mute, courtroom 2.
It's gonna be position number 15, Mr. Leitner.
Okay, Mr. Leitner, you've been charged in case 24 CR 006194D with 2 counts of battery family violence, 2 counts of cruelty to children in the 3rd degree, and hindering or obstructing persons making emergency telephone call. Is there a history, Ms. Harvey?
2 cycles. The last arrest was December 25th, 2022 out of Newton County for driving on a suspended license. There was a nolo contendere. There does appear to be a probation violation hold out of Newton County, Your Honor. Recommendation from pretrial is a level 1 and nothing further.
Your Honor, I believe Ms. Hahn just joined.
Ms. Hahn, are you with me? You have to unmute yourself, Ms. Hahn.
Yeah, as I suspected, Ms. Hahn's a cutie.
Sorry, can you hear me right now? Sorry,
Yes.
the network is out of control.
But her English.
Okay, I've already issued the bond in the matter. He is to stay away from you and to stay away from your apartment. You both can have a one-time escort with law enforcement to retrieve any belongings that you have, okay?
Okay, thank you, Your Honor.
All right, you're welcome. Thank you, ma'am.
Your Honor, this incident happened on May 17th of 2024. Officers responded to 1994 Bent Creek regarding a domestic dispute. The first victim in this case is Victoria Johnson. She's the mother of the defendant's children. She advised that the defendant was staying at her house for the week, watching the kids while she was at work. At some point, she found multiple conversations on his Instagram with other women. She confronted him and there was an altercation. During the altercation, she was holding their 8-month-old child, initials ZL. That baby is the second victim. While she was holding the child, the defendant punched Miss Johnson in the face and then also punched the baby in the face. It appears that it was possibly unintentional. However, the law is clear that if you intend to punch someone and it hits someone else, that's not an excuse or defense to battery.
Punching
the
babies.
Police. I'm sorry, at that point, Miss Johnson grabbed a
That's not
knife
good.
and then cut the defendant in self-defense, of course, from being punched in the face and punching their 8-month-old baby in the face. The victim also told police that at this time, the defendant grabbed the gun in his waistband and threatened her with it. And all of this happened in the presence of their other child, who's a 3-year-old, initials SL. The victim then tried to flee with her 2 children, and the defendant obstructed her exit by holding the door closed. And then she tried to call the police, and the defendant confiscated her phone. Miss Johnson ultimately fled to a neighbor's house and called the police. Miss Johnson had a busted lip. The baby also had swollen lips. We have been in touch with Miss Johnson today. I believe she's also on the line, Your Honor. She states that she and the defendant have been together off and on for 4 years. They have 2 children together. The past month, they have been residing at the incident location, which is the victim's apartment. She states that they do have a domestic violence history. This is the first time that she's made a report. She is afraid of the defendant when he has his gun. She confirmed the events in the warrant and stated that there have been no further incidents since this one in May, and the defendant has been staying with her to help with their children.
I think she should
She
be
would like
afraid of
no
anything
further
without the
violent
gun.
contact and a provision that he has no firearms. Your Honor, respectfully, given the gravity of what happened here and the injuries, the children that are involved, this is a safety concern for not only Ms. Johnson, but the children as well. And especially given Ms. Johnson's reliance on him for childcare at this point, I think there's also an especially high risk for intimidating Ms. Johnson in this matter. The state would still request absolutely no contact here. On the batteries, the state's requesting a $2,500 surety on each, and then a $1,000 surety on the cruelty charges and the obstructing 911 calls for a total of $8,000 good bond. No contact with the victims and the other child as well. Stay away from the incident location.
Yes.
Enroll in family violence
It took over
intervention
2 hours.
program. No weapons, drugs, or alcohol while out on
We
bond.
have finally arrived.
And Your
at
Honor, I
Lord's.
believe Ms. Johnson is on the line.
Ms. Johnson, if you would like to address the court, I'll need for you to unmute yourself and I'll have to swear you in.
Hey,
Yes, good afternoon, ma'am. If you raise your right hand for me, do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes.
Okay, you can place your hand down. Thank you, ma'am. What would you like to tell the court?
I was just looking to let you know that I am okay with him being around us. We haven't been arguing or anything like that for the past few months. We actually been co-parents and actually well recently. So I would like him to be around us because I do need help with the children.
Oh, good Lord.
How old are your children?
1 and 2. Well, one of them will be 1 in September, and the other he'll be 3.
And you're telling me that this has
Not 3,
happened in
but
the
2.
past? You're telling me that this has happened in the past?
Yes.
Okay, and 2 months is not a long time, okay? You're telling me it hadn't happened for 2 months, but that's just, as far as I'm concerned, just yesterday, all right? You're a grown person. He's a grown person. You got a 1 and a 2-year-old that you all are responsible for. You understand? So
Yeah.
I can't have you all, you making the allegations that you're making against him, that you're alleging that he's violent to you. I can't have your children around that. Okay? So I am gonna not have him around you or your kids at this point in time until you all work something out. Mostly for those kids. Those kids are listening and seeing, and you're raising children. All right, thank you for being here, ma'am. Mr. Trejo?
Yes, Judge, we would ask for no further violent contact if the court is going to instill a stay away order from the address. My client would ask for a one-time law enforcement escort. He did indicate that he can, that if the court does impose the stay away order, that he can stay with family in Decatur. My client is gainfully employed. He works as a forklift operator. He's been doing that for some time. He pays the bills at the house. He pays for the children's daycare. He is an Atlanta native with family here, Judge. He went out of state for university and then moved back once he completed. He indicated to me that he does do some feed the homeless operations through his church. And Judge, he does have a Newton County hold, which would continue to hold him, even if he is able to make bond in this case.
And Your Honor, I'll add that our office did request that this case be upgraded to second-degree cruelty to children and add a charge for false imprisonment, and the DA declined to take that. And I know Your Honor typically doesn't order DVIP at this point, but given the ages of the victims, the state would respectfully request if you would consider a DVIP at this point. Thank you.
And Judge, we would object to a DVIP just because that is a requirement under the statute. If he were to be found guilty or enter a plea later on, we would object to the 24-week course that he would be paying weekly as he's enrolled in it before he's found guilty of this crime.
Okay. For each of the battery charges, it'll be a $500 good bond. For each of the cruelty to children charges, it'll be a $250 good bond. For the obstruction, it'll be a $500 good bond. That makes for a total of a $2,000 dollar good bond. At this point, no further contact with Victoria Johnson. Stay away from the Bent Creek address. He can go back to that address on one occasion with law enforcement to retrieve any belongings. I'm not going to keep him away from his kids, but there'll be third-party transfer of any minor children for visitation, and he is to abide by any other court custody arrangements that are that may be made. 1 day anger awareness and no drugs, alcohol, weapons. While out on bond, he has to surrender all weapons that he currently has.
Your Honor, would you consider supervised visitation if you're entertaining custody because one of the victims is one of these children?
Okay, it'll have to be supervised by, it will be supervised visitation by a third party, or to abide by any other court's custody arrangements. All right, no questions. Good luck to you all.
Yes, I got a question. So I'm saying, like, if we do the no contact order, can I just go through the the child support way and do it that way and don't have any contact with her rather than like the bonds and all this other stuff?
How, Mr. Leitner, however you work it out, you just cannot at this point in time have any contact with Ms. Johnson whatsoever. No contact means absolutely no contact. No phone contact, no personal contact, no email contact, no social media contact. So if you work it out through a third party, whoever that third party is, then you can see your children and pay their child support, okay?
Yeah.
All right, good luck to you, sir.
He's
Mr.
thinking,
Jordan,
how
good
can I get out of
afternoon.
my
You have
child
something
support
for me?
from this? My God.
I can't hear you, Mr. Jordan.
Can you hear me now?
Yes, thank you.
Okay. What was the bond for the obstructing charge?
500.
500? And did you say I'm sorry, did you say one-time law enforcement officer escort to get his belongings?
Yes.
Okay, thank you.
Okay, all right.
And Your Honor, this
Yes.
is going to be this position number 19, Mr. Mallory.
Okay, good afternoon, Mr. Mallory. You've been charged in case 24 CR 006199Y with abandonment of dependent child. Is there a history, Ms. Harvey?
Yes, Your Honor, 7 cycles. Last arrest was out of Henry County, September 2nd, 2022, for cruelty in the 3rd degree, subsequent conviction, and a probation violation. There was no disposition listed for that case, Your Honor. Defendant was sentenced on the first offender April 13th, 2023 for battery family violence, subsequent conviction. Also has a 2022 conviction for battery family violence and simple battery family violence. Recommendation from pretrial is a level 2 and nothing further.
Your Honor, that's my case. He was just released from Rogers State Prison for a felony level battery family violence. He looks like that sentence began in April or March of 2023. I only say that because the application for an abandonment warrant was taken out by the mother of his child, whose name is Amir, in August of 2022. And as you know, abandonment charges are for a 30-day period. So this would be for a 30-day period in August of 2022. Probable cause was found by a court during a hearing, and an order for $300 was put in place. So that is the amount he is supposed to pay to be released from jail. I'm not going to ask for any further bond or condition, Your Honor, given that he literally was just released from prison. Thank you.
$300 purge amount?
Yes.
Judge, on behalf of Mr. Mallory, he has been in custody, actually, at the Department of Corrections since September of 2022. And I think when the hearing was conducted, he was in prison. He was picked up and brought straight here. So he's not been out at all the last close to 2 years now, Judge. And I would just ask, under these circumstances, to allow him to be released through UJR He does have family here. He does have 3 kids. It's the oldest that is involved in the abandonment, Judge. But just give him an opportunity to get back on his feet, be able to work, Judge. So that would be my request, so he can catch up and purge eventually.
Okay, so he doesn't have the $300 at the present time because he's been in custody since this. All right, I mean, I think that's, I think that's.
He was in custody starting in September of 2022. This abandonment application was filed in July of 2022 for the month of August of 2022. So the purge amount being issued by a magistrate court is just for the month of August, that he wasn't in jail at that point. But just for clarification purposes.
Yeah, and then I'm not disputing the amounts, Judge. I'm just strictly pointing out that he has been in custody since September, Judge, a month later.
Okay, so you're asking for a UJR, is what you're asking for, and give him the opportunity to get a job and pay.
That's correct, Judge. I mean, the purge is still in the books, so if the family somehow can pay the 300, then that's great. But I'm not sure. I mean, I just I don't know if what his financial situation is right this second, other than he's clearly unemployed, has been unemployed for a couple of years.
Okay, it'll be $1,000 UJR through the jail. Good luck to you, sir.
Thank you, Judge.
That was $1,000 SOB
Yes.
jail. Thank you.
Yes.
Next is going to be position number 21, Mr. Marshall, Stephen Marshall.
Good afternoon, Mr. I'm sorry. Which position is this?
21.
21. This is Mr. Stephen Marshall, right?
Yes.
Okay. What we're gonna leave these to the end of the calendar?
Oh, okay. I didn't see the charge. My apologies, Your Honor.
You're fine. I know that there's another Marshall. That's.
Yeah, he's gonna be Haddad, you want to waive his presence, correct?
Judge, there's some serious mental health issues with the Mr. Marshall position number
20.
20, Judge, and I will waive. I mean, I haven't been able to talk to my. Either way, Judge, I'm not sure. I mean, I don't want to delay it as far as setting the bond. So I'd like to be heard as far as the bond, Judge.
So have you talked to him about a waiver? I mean,
no, Judge, I have not. But I'm in a difficult position because I don't want to keep putting it off as far as the bond. I really don't think it's going to make a difference in terms of him being able to bond out. I'm not. I mean, he's got an open felony case. I'm not requesting for a UJR under the circumstances. I want to at least get him on track, at least for the SAP calendar. And once I have my social worker interview him, and if there's a competency issue, then we'll put him on the competency calendar. I just cannot put him on the competency calendar now without having the opportunity to lay eyes on him.
okay. Well, can't we just put him on for tomorrow and?
Your Honor, he's on a mental health floor. Our mental health floor is 3 North. He's combative. I couldn't actually bring him down to court.
No, and that's fine, but I just need for Mr. Haddad to at least try to talk to him to get his consent for a waiver. I don't know if if you can waive his appearance without talking to him, right?
Well, I don't know what the case law says, Judge, but what I mean, in some circumstances, I've done it before. It's back on me. I'm not. If I make the critical professional error, then it's my license.
No. But what would be the problem with putting this off till tomorrow? I mean, I'll be here tomorrow.
Oh, that's fine, Judge. If the court, yeah, I mean that's fine.
At least
that's fine, Judge. That we can reset him for tomorrow, and I'll go out or have my social worker attempt, or whoever actually is working the SAP tomorrow, to go in person to lay eyes on him. So that works.
Okay, I feel more comfortable with that, Mr. Haddad. So
that's fine.
9:03. All right, very good. Thank you.
Your Honor, for situations like this, we do prefer at least one attorney to come out. So we can bring them upstairs to try to talk to that type of defendant.
Okay.
And we'll do that. I think Norris, sounds like Norris wants me to leave my day off and go all the way to the jail today. But joking aside, Judge, yes, that's fine. I mean, we'll reset it for tomorrow. I'll reach out to Mr. Cook and Mr. McLean, make sure one of them goes to see him.
Okay, thank you.
Attempt to see him.
We'll see him. Well, and we'll circle back tomorrow. Okay, who do we have next?
All right, so that will bring us to position number 22, Mr. Mayers.
Okay. Good afternoon, Mr. Mayers. You've been charged in case 24 CR 006198J with battery and failure to obey a stop sign. Is there a history, Ms. Harvey?
2 cycles, Your Honor. Last arrest was with the Atlanta Police Department in May 26, 2022 for a DUI. No disposition was listed. Recommendation from pretrial is a level 2. Nothing further.
And that's my case, Your Honor. This happened on September the 1st at about 9 a.m. Police responded to 2105 Southwood Boulevard. There they met with the victim, Matthew Rainey, R-A-I-N-E-Y. He reported that he had met the defendant and invited him over to hang out. The victim was seen to have a visible laceration on the left side of his face. He had a blackened, bruised eye and bruising on his shoulder. He said that while they were hanging out, it became clear that the defendant wanted a different kind of engagement and hangout time. And he asked the defendant to leave multiple times. Eventually, he tried to forcibly push the defendant out of his location. And that's when the defendant punched this young man in the face repeatedly and then left in his gray
What I think we're
SUV.
talking about here?
The roommate of this young man, Mr. Rainey, was able to identify the defendant because he'd actually dealt with him previously and reported that he had also been not very nice. Police located the defendant. He was traveling at a high rate of speed nearby after being seen circling in the parking lot. A traffic stop was initiated. He was actually watched as he blew through a stop sign when he knew police were following him. He declined to make a statement to police, Your Honor. So you're looking at the battery for injury, visible injury to the face of Mr. Rainey, and then blowing through the stop sign. We're asking for a $3,000 SOB through pretrial level 2. No contact with Mr. Rainey. Stay away from that location at 2105 Southwood Boulevard. No drugs, alcohol, or weapons while.
Do we have a snuggle struggle?
Thank you.
No objections, Judge.
We did try to reach out to Mr. Rainey. We just haven't had any response yet.
Okay.
The stay away is not an issue, Judge.
You want to
Mr.
go on the
Matthew
love
Rainey is
boat?
on the line and wishes to address the court now. It's your opportunity to do so. All right, for the battery, it'd be a $2,000 signature bond through pretrial level 2. For the failure to obey a stop sign, a $1,000 signature bond through pretrial level 2. Makes for a total of a $3,000 signature bond through pretrial level 2. No further contact with Mr. Rainey. Stay away from the Southwood Boulevard address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Mayers.
Thank you, Judge.
Welcome.
Where was I?
Next,
I was
we're
here.
going to go to position
I'm
number
going anywhere.
24, Mr. Spencer Rickman.
Good afternoon, Mr. Rickman. You've been charged in case 24 CR 006203B with willful obstruction of law enforcement officers and loitering and prowling. Is there a history, Ms. Harvey?
Yes, Your Honor. 2 cycles out of Georgia and 1 cycle out of Nevada. Last arrest was out of Nevada, August 29th, 2022 for larceny. That was a guilty conviction, Your Honor. Also has a 2019 conviction for driving while license suspended and 1 FTA from 2019. Recommendation from pretrial is a level 1. Nothing further.
Your Honor, that's my case. This is an incident that happened overnight from August the 30th into the 31st. Starting around 10:30, report was made at the neighborhood Peachtree Park, which is it encompasses a few different streets. A police officer working an extra job was then flagged down by someone nearby at that location. They were actually doing extra patrols there because of breaking into cars. becoming a problem. He spoke to a victim of 25 Park Circle who reported that he just called 911, which is why the officer had been notified and then flagged down that someone he didn't know was knocking on his front door. He was looking for a friend, he said, but couldn't provide any other information. Later that same evening, officers were called again to the same location, specifically to 833 Martina Drive, where Mrs. Rode, R-O-D-E, first name Lucia, L-U-C-I-A, reported that someone had been trying to make entry into the residence, knocking on multiple doors. Another resident of 594 Martina Drive reported that they had seen the young man in front of you, Mr. Rickman, in the backyard of his location. When police got to 833, at the latest point of the evening, they actually observed the defendant sitting in a stairway that goes into a basement entryway. And they directed him to stop and talk. He disobeyed those commands and then went and was observed actually trying to make entry into unit 833, pulling on the handles and looking in the door. He was observed to have what police indicated were physical manifestations of intoxication or being under the influence of some substance. He did not live at the location and had no reason to be there. This was 10:30 and then at 11 and 12 o'clock at night. After when police went to handcuff him, he tensed up, he resisted, he used his obstruction, Your Honor. We'd ask for a $1,000 SOB through pretrial level 1. Stay away from the location. That's the Peachtree Park neighborhood, specifically Martina Drive. And no drugs, alcohol, or weapons, and perhaps a SAET if that is appropriate based on defense counsel input. Thank you.
Your Honor, we do not have an objection as to the recommendation other than the SAT. I did not get an indication, at least at this time, that there's an issue. There may have been a couple of days ago, Judge, but he does have family. He lives in Lawrenceville, Judge. I think his dad lives with his dad, although I'm not 100% sure about that. But in any event, due to the nature of the charge and his lack of serious criminal history, I would ask the court to follow the recommendation of SOR.
So he's not residentially challenged?
No, Judge. No, he is not.
Okay. It'll be a $500 signature bond through pretrial level 1 on each charge, makes for a total of $1,000 signature bond through pretrial level 1. Stay away from the Peachtree Park neighborhood, particularly that, I believe, Martine Drive, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Rickman.
Thank you, Judge.
You're welcome.
Next, we have position number 27, Mr. Roy Sally.
Good afternoon, Mr. Sally. You've been charged in case 24 CR 006206F with simple battery and willful obstruction of a law enforcement officer. Is there a history, Ms. Harvey?
Yes, Your Honor. 4 cycles with arrests out of Georgia, DC, and Arizona. The last arrest was out of Fulton County, March 8th, 2024, for theft by shoplifting. He does appear to be on probation out of Clayton County for 3 counts of aggravated battery and battery. Sentenced December 6, 2022 to 7 years probation. Recommendation from pretrial, Your Honor, is a UJR jail and nothing further.
Your Honor, this is an incident from the 30th of August at 5 p.m. Police were flagged down by an employee at the CVS at 235 Peachtree Street. It was reported that the defendant struck someone in the face, an actual other customer at the CVS. He was seen walking nearby. Officers directed him to stop and talk. He looked at police and then turned around and walked the other way. When officers caught up to him and tried to detain him, he pulled away and refused to turn around. They actually had to deploy tasers. Officer Matthew Gordon deployed his taser after the defendant refused to get up off the ground and was physically
Let's play the body cam.
resisting. The victim, Freyana Bostic, No, Miss Bostic was the CVS employee. She was a witness. This is also caught on surveillance. The victim's name is Joseph Martel, Martel. He reported that he'd been standing at the counter talking to the clerk, and the defendant was there as well, and started to think that someone was talking about him. And when he tried to explain to the defendant that he was misunderstanding what had just happened, the defendant made verbal threats to harm him and then struck him in the jaw, and it put him to the ground, one hit to the ground. That again was captured on surveillance. We'd ask for a $2,000 surety bond, Your Honor. He's on probation for aggravated battery out of Clayton County. We'd ask for no drugs, alcohol, or weapons, and to stay away from that CVS location at 235 Peachtree Street. Thank you.
John?
Your Honor, on behalf of my client, he's 32 years of age, Judge. He does have a stable residence. He's currently unemployed, although he informs me that he's done a couple of years of college. I would just ask the court to follow the pretrial services recommendation. I can't speak as far as his history, and I know he does not have a hold right now from Clayton County, but that would be the request. I think there's a little bit more to it as far as what transpired at CVS, but in any event, that's a request of the defense, Judge.
All right, for the simple battery, it'll be a $2,000 signature bond through pretrial level 1. The obstruction, $1,000 signature bond through pretrial level 1. Makes for a total of a $3,000 signature bond through pretrial level 1. 1 day anger awareness, no further contact with Joseph Martel, stay away from the CVS on Peachtree Street, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Sally.
Next one is going to be position number 28, Mr. Joseph Smith.
Good afternoon, Mr. Smith. You've been charged in case 24 CR 006207A with 2 counts of simple battery family violence, 1 count of battery family violence, and 1 count of cruelty to children in the 3rd degree. Is there a history, Ms. Harvey?
Yes, Your Honor. 1 arrest from Alabama, out of Alabama, April 1st, 1996 for domestic violence. Recommendation from pretrial is a UJR jail. Nothing further.
Your Honor, this is an incident that occurred at a hotel on August the 31st. We did try to get in touch with Mrs. Wendy Smith and were not able to get her on the phone. I do see she has joined us on the Zoom, so if you might call for her after I give you just a few brief points of information. The police were called because the defendant was intoxicated and behaving violently. On scene, they spoke with Wendy, his wife, who reported that she'd been grabbed by the neck by the defendant. He was seen, his son, who is the victim of the battery, in this case, Your Honor, Asher, is 16, maybe 2013 date of birth, young, was seen to have a puncture wound, redness, and swelling on his back from being shoved into the corner of the dresser. And his daughter was shoved into a door frame at the location. The 3 individuals on scene, his family reported that he was intoxicated and that he was being belligerent and violent. The defendant had passed out and was asleep when police made contact with him. They actually had to get the hotel staff to let them into the room. The victim, the mom and her children hid in the bathroom until they were able to escape the room. The defendant passed out, and once police made contact with him, I don't think he had much to say, Your Honor. We would ask for a $3,000 SOB through pretrial. We'd also ask for no contact. And this is an incident location, I believe, is a hotel, but we can get some more information from Mrs. Smith if you'd like. We'd ask for no drugs, alcohol, or weapons. Thank you.
Ms. Smith, I see you on the line. If you would like to address the court, now is your opportunity to do so. If you'll raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Yes, thank you, ma'am. What would you like to tell the court?
Greg and I have been together for 21 years. He's never acted like this before. He's never been violent to myself or the children before. I do feel safe around him. I do think he needs help with his alcohol. So I have already started looking at rehab facilities. So my wish is that we do continue to have contact with him. However, I will take him to a rehab facility. I've already called places today to understand the process and reached out to my insurance company. But with it being a holiday, they're obviously not in. So my thoughts were I'll take him to a hotel today to stay there. And then tomorrow I will take him to a rehab location. I've found 2 so far.
And you know,
Okay,
the age of the children, the little boy who is the victim of the battery is 11, and his sister, the daughter of these 2, is 15, I believe. Is that correct,
14.
Ms. Smith? 14.
Yes, ma'am.
Thank you.
and you all live in Alabama?
No, sir. That we live in Dawsonville, Georgia.
Okay,
That other charge was before I knew him.
Where was this incident?
It was in Alpharetta at a hotel.
And what were you doing in Alpharetta?
We were at the Stone Temple Pilots concert at Ameris Bank.
Got it. Okay. Thank you.
all right. Thank you, Ms. Smith. I appreciate you being here this afternoon. Mr. Haddad?
Your Honor, no objection as far as the signature bond through pretrial services. I would ask there'll be no violent contact. I actually got hold of Ms. Smith earlier, and she related to me exactly what she just told the court. She's trying to basically just going to drive him to a place to address his issues, Judge. But she did indicate she wanted to have contact with him and at least the kids. So I would ask the court to follow that suggestion.
Okay, for each charge, it'll be $1,000 signature bond through pretrial level 1, makes for a total of a $4,000 signature bond through pretrial level 1. No further violent contact with Ms. Wendy Smith or with the 2 minor children. No drugs, alcohol, weapons while out on bond. Good luck to you both, Mr. and Mrs. Smith.
Thank you, Your Honor. Your Honor, he had 2 charges of cruelty to children. Was one of them NOD?
Yes, one of them has a NOD.
Thank you.
Yep, thank you.
You good. Next is going to be position number 31, Mr. Isaac Thomas.
Okay. Mr. Thomas, good afternoon. You've been charged in case 24 CR 006210J with simple battery family violence and criminal trespass family violence. Is there a history, Ms. Harvey?
19 cycles. The last arrest was May 19th, 2022 out of DeKalb County for battery family violence and willful obstruction of a law enforcement officer. No disposition was listed, Your Honor. That appears to be an an open case. There's also an FTA hold out of DeKalb County. In addition, there are convictions from 2014 for possession of marijuana less than an ounce, 2017, simple battery against a person 65 years or older, 2018 conviction for theft by taking. Recommendation from pretrial, Your Honor, is a level 3 and nothing further.
Your Honor, this is my case. This is an incident from the 31st, 2135 Godby Road in College Park. Police were called and noted in the report that they'd been to the location on numerous occasions for damage to property similar to this. The victim in this case is the live-in sister of this defendant. Her name is Conethia Thomas, Coanethia. She's 42. We've been in contact with her today. Basically, he damaged a mirror, caused an injury to himself when he broke the mirror on the wall and tried to take a cell phone from someone else in the home. He struck the wall multiple times while upset. And then when his sister tried to talk to him as he was in police custody in front of police officers, he spat in her face. The 2017 simple battery conviction on someone older than 65, as well as a 2011 battery family violence conviction that this gentleman has, is a concern. We did speak to Mrs. Thomas. She says that he has a diagnosis and he needs to be on medication. And so it seems like that might be the issue. She's honest and says that there is domestic violence history in the past, but he hadn't been arrested based on exchanges with her in the past. She does not want him to return to the location, Your Honor. If you could sound for Mrs. Thomas, you can get some more information from her. But at this point, the state would be asking for no contact. We'd ask for $1,000 SOB through pretrial. I think they said level 1. No drugs, alcohol, or weapons, to take medications as prescribed, unless, of course, he needs an evaluation and some support with that. And we'd be on board with that as well. But to stay away and have no contact, Your Honor. Thank you.
Mr. Dodd?
Your Honor, under the circumstances, defense will consent to the recommendation. I would just ask a one-time police escort for Mr. Thomas to retrieve his belongings. And I'll just have to make arrangements to live. He also has a brother, Judge, but there's no need to live with his sister anymore.
Okay. For the simple battery, it'll be a $2,000 signature bond through pretrial. It's my understanding pretrial's recommendation is level 3, so it'll be level 3. $1,000 signature bond through pretrial for the criminal trespass makes level 3, makes for a total of a $3,000 signature bond through pretrial level 3. No further contact with Ms. Conethia Thomas. Stay away from the Godby Road address. He can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond, but he is to remain on any prescription medication that he is currently prescribed. Okay. All right, Mr. Thomas. Good luck to you, sir.
Okay, I officially surrender. I streamed for 3 hours and all I got was this janky purse. It did actually get worse, but not in a fun way. When it got worse, it was baby punching. It's the last time I tried to stream on a holiday. Thank you all for sticking with me. Sorry, it never it never got good. It just never got good. That's the way it is. I think I'll put this one in the memory hole. I think that's the only thing to do with this stream. I mean, I've been on these wild goose chases before, and usually somewhere along the way something interesting happens. But not today. That's the way it is. We try again tomorrow. We try again tomorrow with actual court. Maybe something interesting will happen. You guys are the best. Thanks for coming out. Behave yourselves. Don't get arrested. I know it's a holiday. Because I'm not bailing you out. I'm not bailing you out when I'm in Chicago. I'm certainly not bailing you out from Cartagena. I've never bailed anyone out in my entire life. I'm not going to start now. See you soon.